First of all, I welcome you all to the legal workshop of the post MVP startups under the All India EdTech Challenge and Masterclass series. This is an initiative taken by Amazon Web Services at Start along with ecosystem partner Atal Innovation Mission. So today we are going to discuss about the most important aspect of the startup journey, which is the legal aspects of that. And to share those expert insights with all of you, today we have with us Ms. Lavleen Gupta, who is the founder of LGA and has been dedicatedly looking at the legal aspects of various startups and bigger companies that they have in their portfolio. And just to give you a brief about our mentor, Ms. Lavleen Gupta, she is an experienced owner with a demonstrated history of working in the legal services sector. She's skilled in company secretarial work, corporate law, intellectual property, corporate governance, and company law. She is a strong business development professional who's graduated from Campus Law Center. So we welcome Ms. Lavleen Gupta. Ma'am, over to you now.
Thank you, Gaurav. Thank you for the brief introduction. I believe all the participants are startup owners. Is that true?
Yep. We all are startup owners.
Okay. The first step for startup is what the startup is. The government has given recognition to the startups, but not to all startups. What is the eligibility for getting the registration for government? First of all, we should understand that thing. There are various modes of entities where the startups can be registered. The entity could be either private limited company, partnership firm, or limited liability partnership firm. I'm presuming that you are aware of these basic terms. If anybody has any question, even in between, they can ask if that is related to the slide which I am talking about. So the startup which is to be registered should be either as a private limited company, partnership firm, or limited liability partnership.
So mine is a private limited, but I often hear this question as to from many other entrepreneurs as to what should be the way. Should we first start with an LLP and then move on to a private, or should we straight away go into registration for a private company?
That depends upon our viewpoint, where we are looking for. If we are looking for some foreign investments and some big investments, then private limited company is the better option. LLP is limited liability partnership, where two partners are joining hands to start the business. Whenever any investor comes, you have to give the contribution and he would be joining you as partner. So as per my view, private limited company is a better form amongst all these three, though government recognize both the three for registration as startup. But as per my view and my understanding, and depending on my experience, my suggestion would be to better to go with private limited company. In that structure, it would be easy for you to identify and distinguish between promoters and investors, and the ultimate control would remain with the founders. In LLP, it can be possible, but would be difficult to manage after a certain stage. Then you will have to again go for conversion of LLP into private limited company. Next criteria is startup can be registered only up to 10 years from the date of incorporation. Means age of the startup cannot be more than 10 years. Next, turnover should not exceed 100 CR from the date of incorporation till the date of registration in any of the financial years. Next important criteria is that the entity is working towards innovation, development, or improvement of the products. This is the most important criteria on the basis of which the registration is granted or it is rejected. You have to show that the services you are going to provide or the product you are about to sell in the startup is something related, which is innovative, or it is something new. If it does not fall under any of these criteria, then another criteria is if it is scalable business model with high potential of employment generation and wealth creation. If it is something which is not innovative, but the model is like that you can generate, there is high potential of generating employment or wealth creation, then also it could be considered as eligible for startup registration. The registration is generally online registration. In online registration, we fulfill all the documents which is needed to be supplied to the government. They examine our application and they give you one chance also. If they have some queries, if you can reply it positively, they'll grant you startup recognition. Apart from startup recognition, once we have set up our entity and we got startup registration, whether we got startup registration or not, that is optional. But once we have started the entity, there are certain compliances or certain works which we need to take care of. What happens, we incorporate the company and we don't know the next step, how to go ahead, because there is nobody to guide us at what stage we are supposed to do anything. So I have gathered a bit of information of that sort, which can give you a bit insight what things actually you need to do with the entity. Because when we go for any investor funding, they every time they do due diligence, and most of the startups, even if they have good potential, but they fail in due diligence because of lack of expertise knowledge. So my view of presentation is to make you aware what all things you need to take care of after getting your entity incorporated. One of those is business licenses, where various licenses needs to be taken by the government. After the incorporation of the company or LLP, whatever it is required to get that registered under Shop and Establishment Act. Every state has its own Shop and Establishment Act and its own requirements and eligibility. So you need to take care where the registered office of the company is situated, and according to that, that license should be applied for. Other licenses are industry-based licenses. Suppose you are doing something which affects the pollution, you need to take the license from water pollution, air pollution, or if you are into food industry, then you need to take FSSAI license. Those are all depending upon the activity which you are performing. Based on that, licenses needs to be taken. Another thing is website development. In today's scenario, it is always recommended to have a good website which could become a medium for you to interact with the investor and to make your presence public through e-mode. Website should be properly developed and should have all those minimum informations which could define you. Another important thing is intellectual property rights. Whatever you are doing, since you are doing something innovative or which is a new process or something new, then that should belong to you only. Intellectual property rights consist of three things: copyrights, patents, and trademarks. Copyrights are for the material, suppose any content, books writing, literature writing, that covers under copyrights. Trademark is just like your brand registration. If you are working in, if you want to work under some brand, that registered under trademark, because you never know when you will become big, and that mark should belong to you only. For that, it is necessary to get that registered. And patent is for the processes or systems like that you can do, take patents also. Now we come to the benefits which startups can get. After getting registration from government as startups, there are various benefits which government is allowing to us, but only in the case when we get startup recognition from DIPP. We get certain tax benefits in income tax. For 3 years, our income is not taxable, and many more like that. Another thing is when we issue shares to any investor, the general rule is that you cannot issue shares at more than fair market value. Since ours is a new company, the fair market value of the company would not be much higher. Based on projections, we can calculate and get the fair market value, but the shares cannot be issued more than fair market value. But it is a benefit given to startups that even a startup can even issue shares at more than fair market value and would not come under tax bracket. Similarly, under labor laws, whenever we start doing the business, various labor laws becomes applicable to us. Some labor laws become applicable from the date of registration. Some becomes applicable after we get employed certain number of employees. Depending on that, labor laws becomes applicable to our company. But to startups, government has again given exemptions where we can certify there is no personal inspection for 3 years by the inspectors. Whatever you will certify, that is taken by the government as it is. Another benefit, startup intellectual property protection scheme. What the government has done in that scheme, this is called SIP scheme. Government is you can take intellectual property registration through this scheme where you are not required to pay to the professional who is taking these intellectual property rights for you. You just have to pay the government fees. That's it. Payment to the professionals will be done by the government. So this scheme was earlier available up to March 2020, but now the government has again extended it to for further 3 years, and it is applicable till 31st March 2023. So if we get startup registration, we should take benefit of this scheme. Another thing is GEM registration. GEM registration is again a government portal where government is ready to take services of yours. Means if you are a seller and something is needed to government, you can sell your product at this GEM portal to the government. So government is making interactive portal where the buyer and seller can meet, and buyer would be the government itself. So it is a good benefit which is given to startups. Up till here, if anybody has any question, we can take up that.
Am I audible now?
Now you're audible.
Yeah. So ma'am, I just want to ask you, this SIPP scheme means if we are 2 directors and we need to pay professional fees every year after registration, so that will be, we don't need to pay, correct? That's what the...
What you intend to take?
Startup intellectual property protection scheme, what you are talking in that, professional fees we need to pay to the government, correct?
No, you are not required to pay any professional fees. Only government fees, government charges would be taken from you, and you are not required to pay professional fees for applying for the trademark or copyright or patent.
Okay, thank you.
Yeah. Should we move ahead?
Excuse me, ma'am.
Yeah.
Yeah, sorry, my video is not working. I just wanted to understand what all things come under the purview of SIPP scheme. What all things can be, registered with the government as a intellectual property, startups intellectual property protect under this scheme?
Under this scheme, what government has done, it is a platform where startups and the service providers meet. But you don't have to pay to the service provider. You can, suppose you want to take trademark registration. If you will go to any other professional or attorney for trademark registration, he will charge you X amount. But if you go through this SIPP scheme, you don't have to pay any professional charge. Only whatever is the government fees for your application, you have to pay that. It is only for registration of trademark, copyright, and patent.
So, ma'am, I just want to ask, I have already registered my trademark and copyright 5 years back, but we have not registered company as a private limited. We are planning now because we were into a research thing. So can we get that money back from the government or something like that in this?
No. Once anything is gone, government do not return the money back.
Okay.
Yeah, hi, this is Sudhin Baraukar. So just want to provide a few inputs out here, if I may be allowed. So just to Google the Maharashtra state government scheme for IP incentives and subsidy for startups. So they're giving startups, if it's a DIPP and MSME registered startup, you get a 2 lakh subsidy for a local India patent and a 8 lakh rupee subsidy if you are firing it abroad. So go and take a look at that scheme, check the applicability. In case you have done something previously, try to rewire it and reconfigure it and start afresh. You will get the benefit of this entire subsidy, 2 lakh rupees for a local pan India patent and 8 lakh rupees for a foreign patent. So just check that. Okay, thanks.
Thank you so much.
After getting various registrations, what we intend to do, we must be strong in our contracts and agreements. It is necessary to get the documents done at an early stage, like founders agreement. Generally in startups, we 2 or 3 people join hands together to start a new business. To have a better understanding amongst themselves, it is better to get the founders agreement executed. In the founders agreement, various kinds of arrangements which are there amongst the founders that are defined, so that there won't be any dispute or any confusion at a later stage. Because after we pitch to the investors, the scene should not be like that, that we amongst founders are not very much clear about ourselves. So better to avoid that situation and get executed some founders agreement. Another important agreements are works contract. We hire people, we should not do anything verbally. We should always enter into an agreement even with the employees, so as to have better clarity and understanding and to avoid any confusion in future. Next is non-disclosure agreements. We are very sensitive about our information, our work, so it's better to get non-disclosure agreements with the people to whom you are dealing with, because what is important for you is your idea only. So that should not be taken advantage by anybody else. So it's better to always do non-disclosure agreements with the persons who are doing any kind of work.
Ma'am, in case we are pitching to an investor and they are asking us for the second meet, so should we go non-disclosure prior, or if after that, when we are having a commercial terms to be agreed, that time we should go? As per your...
In the second meet, if you are comfortable with the investor, you can go ahead with NDA, otherwise later on stage.
Sure.
Now I am briefing some certain provisions of company law which are very important if our entity is a private limited company. Company law is a bit stringent as compared to LLP, but if we know the compliances which we have to do, then it is not difficult. But if we'll not do, then it may lead to certain penalties and additional fees. To avoid that, we must have an understanding of compliances under company law. Starting with the incorporation of the company, we get the registration certificate. Next step is to open the bank account and get the subscribers amounts deposited in the bank account. After getting subscribers amount, it is necessary to obtain certificate of commencement of business from registrar of companies, because without this certificate you cannot commence any business, you cannot take any loan, nothing can be done. So it is the first step to obtain certificate of commencement of business. Then we get our letterheads printed, but we don't know what the Companies Act prescribes for the things to be mentioned on the letterhead. There are certain things which are mandatory to be mentioned on the letterhead of the company, like name of the company, SIN number, registered office address, email ID, contact number. These 5 things are mandatory. Apart from that, if you have a website, you can mention it. If you don't have the website, you can leave that thing. Another important thing is at the register, you should maintain a proper registered office, and a display board should be there outside the registered office, which clearly and eligibly describes the name of the company. After that, it is required to appoint statutory auditor of the company. Within 3 months from the date of incorporation, the auditor should be appointed. Every entity should engage the services of any practicing company secretary who can guide you in time for the compliances under company law. Next, you should engage some legal professional also who can help you in drafting of various agreements. Then in company law, there are certain requirements which needs to be complied with, like holding of board meetings. The law prescribes that at least 4 board meetings should be held in one financial year. And those meetings should be properly recorded in minutes book of the company. Similarly, shareholders, certain agenda items requires the approval of shareholders, for which we need to hold general meetings. And general meetings should also be recorded in the minutes book of the company. Minutes of books, maintenance of books of accounts. It is necessary to maintain books of accounts from the initial days itself, because at the end of the financial year, you have to get your accounts audited even if you have not started any business. So it's necessary to maintain all these things from the very initial days. There are certain statutory registers which needs to be maintained under company law, like register of shareholders, register of directors. If any share transfer happens, that needs to be recorded in these registers. If there is any related party transaction, that needs to be mentioned. These ways, there are certain registers which needs to be maintained. Another important thing is try to get all the compliances done in time. Suppose after convening annual general meeting, financial statements needs to be filed within 30 days of annual general meeting. Don't wait for the last day and get it done at the earliest. After 30 days, 100 rupees penalty per day would be implicated. To avoid those penalties, it is not only a monetary liability, but it gives a bad picture in front of any investor or even in the eyes of the government. So always try to do all the compliances in time. It is required to take disclosure from the directors how much we need to take disclosure from the directors regarding their relationships with their relatives, so that there are certain transactions which are prohibited or which needs to be taken care of as related party transaction. But if the board does not know the name of your relatives, or if you are connected in any other company or you are shareholder in any other company, how the company or the board will come to know? To curb that thing, it is required to get disclosures from all the directors of the company. There are certain restrictions on borrowings of the company. Company cannot borrow from anybody. There are certain people through whom a company can borrow. Similarly, company cannot give loan to everybody. Directors themselves cannot take loan from the company. If they want to invest the money, then also there are certain restrictions. So these are the key areas which needs to be taken care of before doing anything. There are certain things, if once we have done, we cannot go back. So before taking any such kind of financial transactions, better to have some expert advice. Regarding approval and adoption of financial statements, every company is required to maintain books of accounts for the financial year. And at the end of the financial year, suppose 31st March 2022 is the ending date of the financial year, then within 6 months from the end of financial year, annual general meeting is required to be held. And before holding annual general meeting, the financial statement should be approved by the board and audited by the statutory auditor. After that, with the gap of 21 clear days, annual general meeting can be held. So it is very important to follow this procedure to avoid any penalty. Secretarial standards have been prescribed by the Institute of Company Secretaries and Ministry of Corporate Affairs. So we should take care of those secretarial standards on routine basis. Because if we are not following those secretarial standards, our reports would be qualified. Another important thing is MSME declarations. All the creditors with whom we are dealing or any vendor, we should obtain declaration from them whether they are registered under MSME or not. Because it is a law under MSME that you have to make the payment to all MSMEs within 45 days. But if you don't know a person whether that entity is MSME or not, you may miss that. So make it a practice, once a new vendor is added, take MSME declarations from them, whether they are MSME registered or not. Another important thing, how the funds can be raised. In private limited company, there are various modes of raising the funds, like equity shares, preference shares, shares with differential voting rights, sweat equity, and ESOPs. In equity shares, the shareholder gets voting right as well. And in preference shares, there is no voting right. Further, in preference shares, there are various kinds of preference shares, like convertible preference shares, non-convertible preference shares. So depending on your understanding with the investor, you can choose the securities which is comfortable to both the parties. Further, there are certain shares with differential voting right. Even if I am issuing equity shares, I can restrict the voting right. It is not like that if I am having 100 shares, every time I will have 100 votes. If I issue shares with differential voting right, for 100 shares, I can have only one vote also. So that depends on at the time of issue of shares, we will decide what kind of securities we want to issue. Another thing is sweat equity. Sweat equity is when you get, when the company gives equity to a person who is working for the company, not for the cash contribution, but for his working, you are giving them equity. That is sweat equity. ESOPs are shares, which is, it is not actually shares, it is an option given to the employees to take the when they can take the equity shares at a later stage. In the initial stage, you are offering them a right that they can take a share at a future date at a predetermined value. So this is the most important form of compensation given to employees, because in initial days, startups are not so cash friendly. So they compensate employees by way of some way in cash contribution, other through ESOPs. Yes. Once we have received the funds, there are again certain compliances which needs to be done. Suppose we have received the money, but we have not intimated to registrar of companies, then it is a big default. How to take the money, in which bank account money should be taken, at what stage money should be taken. These all are very, very well defined under company law. So before taking any fund, get the expert advice, and only through expert advice only take any money in the account, because there are restrictions. Even if you want to issue the shares, but you have to do certain pre-compliances and certain post-compliances. Once you get the money, nothing can be reversed. And if the investor is a foreign investor, then apart from company law, Foreign Exchange Management Act is also applicable to them. There are certain restrictions under FEMA in which activity, how much percentage you can take from foreign investor. So that is a very detailed study, but whenever you get any foreign investor, do understand all these things before accepting any remittance from them. Another important thing is, whenever you get the shares, either to founders or to the investors, share certificates must be issued and stamp duty must be paid. This is the most ignored step, and in the later stage, it creates a huge problem. So every time be cautious of this thing, that whenever you issue shares, you immediately issue share certificates and pay the stamp duty to the state where the registered office is situated. After getting funds from the investors, you need to enter into agreements with them. Generally, they themselves pushes for these agreements, but you should be aware that these agreements needs to be signed, like shareholders agreement and share subscription agreement. What is actually defined in agreements, I'll give you a brief gist of that. In shareholders agreement, what happens, what is decided between the investor and founders, that is clearly written over there. That if it at a later stage you want to exit, how you can exit, what are the preconditions for that, if investor wants to exit, how they can exit, what are your rights, what are your duties, whether the investor would be taking a board seat or they would be appointing some observer. All these things are very clearly and in detail, they are defined in these type of agreements. If sometimes such kind of arrangement is also done, you transfer some of your equity to them, that is covered under share purchase agreement. You agree to sell some part of your equity, which is your existing equity, to the investor, then you must enter into share purchase agreement. So these are some basic documents which you should be at least aware of, so that when the investor says, you must have a brief idea of these things.
Ma'am, this all documents will be having a format, right?
No, they are not formatted documents that needs to be drafted by some legal expert.
There is no standard format where only blanks has to be filled.
No, because every transaction has a different kind of understanding. Some people make agreement of nearly 100 pages. Some may get it done in 20-25 pages. So it depends on you and the investor what kind of details you want to make a part of your agreement.
So, ma'am, there will be any such format which is completely with all the details only to know as a startup to, we should know prior what are the terms and conditions can be, we'll get before from the financiers.
That you can do Google and get the various agreements of other startups. So you can have an idea ki what are the contents of these agreements. But whatever is decided, that needs to be drafted. Means there is no such template sort of things where you can put in your fill in the blanks and you will get a proper agreement.
Okay, thank you.
Yeah, most of these templates are available in the public domain. So most of the VC templates are held as a standard. At times, incubators, accelerators, angel investors may have a few tweaks to that template or the shareholder agreement or the what we call as sometimes a term sheet. But more or less, it's the VC term sheets that are standard, and they follow, everybody follows the same kind of format. There could be some tweaks here and there, but these are all available in the public domain. In case you need any help, you may just connect with me. It's Sudhin Baraukar. Just connect with me on LinkedIn and I can send you those details.
Put your address in the chat box.
Yeah.
Thank you.
Now we can take up any questions or queries which anybody has.
Ma'am, one more thing. As you said, there is an annual general meeting and 4 meetings to be held in the year, correct? And an auditor has to be appointed within 3 months of the thing, correct?
Yeah.
So, when exactly you told that 6 months prior you have to be sure about your books of accounts, and then you have to hold an annual general meeting. So I got confused. Exactly what is the term period when annual general meeting has to be held? Because
Okay.
auditor is appointed in annual general meeting, right?
No, I'll explain. Suppose your company is incorporated on 1st November 2021. Your financial year will end on 31st March 2022. After 1st November, you can get your statutory auditor appointed in the board meeting. First auditor is not to be appointed in annual general meeting. It is to be appointed through board only. You appoint that statutory auditor. After March 2022, you prepare your financial statements, get them audited with the statutory auditor, and hold the meeting by 30th September, or in case of first annual general meeting by 31st of December. before that annual general meeting, you should be ready with your audited accounts, and those audited accounts needs to be circulated to all the members.
So the year, if I'm starting from November, then it is ending in September, right? Not in the March, and then I have
Year would be ended on 31st March, and annual general meeting to be held up to 30th September.
that every year it will continue with
Every year it will continue like that.
Okay, thank you.
I just only want to wish good luck to all the startups. Kindly comply and move further.